Hello, everyone. Thanks for joining us. Today, we are here to talk about abortion rights, and we're going to try something a little bit different. When we created ASP, the main goal was to connect people to their lawmakers so that lawmakers could directly explain issues that they felt strongly about that affect us in our everyday lives. Since the overturning Roe v. Wade, we got a lot of questions and a lot of interest in the confusion that's been created around states passing their own laws. And so we felt the best way to try to address that was to bring in an actual expert in law and in reproductive law. And to that end, we are very, very happy to have NYU Law Professor Melissa Murray join us. Professor Murray is a faculty director for the Burnham Women's Leadership Network at New York University, and she's a leading expert in family law, constitutional law, and reproductive rights. Professor Murray's experience also includes clerking for Justice Sotomayor, clerking at the U.S. District Court of Appeals for the Second Circuit, and the U.S. District Court for the District of Connecticut. And she's also the co-host of her podcast, Strictly Scrutiny. Professor Murray, thank you so much for joining us today.
Thanks for having me.
We're going to quickly turn this conversation over to students in the ASP community who submitted their thoughts about abortion and changing the legal landscape. First, we want to give our thanks to our partners at Close-Up Foundation for working with us on today's conversation. As an additional resource for teachers, students, or really anyone interested in furthering their education on the topic, Close-Up has created a resource guide with relevant information on reproductive policy and access, as well as background about the current abortion debate and some questions for teachers to stimulate civil classroom discussion. These resources are available on the ASP Homeroom website at homeroom.astartingpoint.com.
So, Professor Murray, before we start, is there anything you wanted to add to help kick off the conversation today?
No, I'm really glad to be here. This is giving me all kinds of street cred with my 11-year-old who thinks that my job on most days is pretty boring, but today it's especially cool. So many thanks.
Our secondary goal at ASP is to make people cooler with their children, so that's great. So let's dive right in. Following the court's decision to overturn Roe v. Wade, many laws have been passed at the state level, both restricting abortion access and also trying to ensure it. Can you explain a little bit about the mechanism around state law? What are the governing bodies? What is the process in general? And what is the length of time that can happen for these laws to take effect?
It's a really terrific question. A lot depends on the state itself. Each state will have its own procedures, but for the most part, there's legislative action. So the state legislatures will take measures. They may hold hearings that might make things take longer, or they'll just simply sponsor bills, have the bills presented to both chambers of the state legislature. Most states have two chambers. Only Nebraska has just one chamber. And once it passes both chambers, it will then go to the state's governor and it will be signed into law. So legislative action is one aspect of this. There can also be executive action. So the state governor, to the extent permitted in the state's constitution, can do executive orders that may go a long way to either restrict or to enhance reproductive rights. There's also the prospect of popular legislative action, which is to say that there might be a voter referendum in an upcoming election that would either secure or limit reproductive rights. And the referendum process is typically something that is more prevalent in Western states. So California, for example, has a voter initiative process, Proposition 8, which was the 2008 amendment to the California Constitution that limited the recognition of same-sex marriage. That was something that was passed by the voters in an election. So that's another aspect. And then finally, there is judicial action. So just like at the federal level, we have a Supreme Court, there are usually courts of last resorts in all of the states, and they can be a measure through which you can have legal challenges that reach the state courts about various laws. So you could actually invalidate a law as inconsistent with the state's constitution if you successfully bring a case through the state's courts. So those are a couple of different options. Some of them are more time consuming than others. Like litigation and judicial action can take a long time. Executive action is much more expeditious. Legislative action can be expeditious, and the referendum process can be lengthy in the startup period, getting it on the ballot, but can actually be pretty quick once you get it to an election and to a vote.
Well, given that the Supreme Court overturned the constitutional right to abortion, does Congress have the power to craft a national abortion law at this point, or is it strictly up to each state to decide?
The majority opinion in Dobbs said that this is returning the question of abortion to the states for democratic deliberation. And That's true, but that doesn't mean that there isn't a role on the federal level for Congress to take. And Justice Brett Kavanaugh actually acknowledged this in his concurring opinion. He said that this would be set for democratic deliberation by the people through their state legislatures or Congress. And what that means is that we could definitely see some action from Congress, whether it is to codify the protections of Roe versus Wade in a federal statute, or we could see actions from Congress to limit abortion rights on a national level. So, Congress could giveth or taketh away. I think right now, the prospect of Congress codifying reproductive rights is pretty dim. It would require both houses of Congress to pass this law. Right now, there is a progressive majority in the House, and they have passed the Women's Health Protection Act, but it isn't subject to a filibuster-proof majority in the Senate, so it really doesn't seem to be going anywhere. But what is perhaps more chilling for progressive audiences is that we have a midterm election coming up where control over both houses of Congress is really in the balance. And if the Republicans win control of both houses of Congress in 2022 and then win the presidency in 2024, I think it is incredibly likely, indeed a foregone conclusion, that we will see a federal ban on abortion that will remove this from the states entirely and just as a blanket prohibition throughout the country, make reproductive rights much more limited, a ban on abortion across the country.
I'm going to turn it over to the questions from our students, but I just have to ask you a quick follow-up. What's fascinating is where's the handoff between states' rights and federal rights? If the point of overturning Roe v. Wade is that it shouldn't be a federal law, wouldn't it be, does that fly in the face of that logic to then make a federal ban on abortion?
So, I think it's important to understand the nuance of the opinion. The opinion didn't say that there shouldn't be a federal law. It said that the court should not decide that there is a constitutional right. So Justice Kavanaugh's concurrence is really sort of the best model of this. He insists that the Constitution has nothing to say about abortion, and therefore the Supreme Court, which is the ultimate arbiter of what the Constitution says, should be studiously neutral on the question of abortion. And in 1973, the Roe Court was not neutral. It actually blessed a right to abortion that, according to Justice Kavanaugh and the majority, the Constitution did not countenance. So this opinion merely removes it back to the state and for democratic deliberation, but ultimately the real arbiters of this issue should be the people, whether through their state legislatures or through the federal legislature and their representation in Congress. The thing that's really interesting about this is that the court has emphasized the importance of democratic deliberation and returning this issue to the people to make their voices heard at the ballot box, whether it's at the state level or the federal level. But the court over the last 10 years has actually made it harder for the people to register their preferences at the ballot box. It has dismantled a key provision of the Voting Rights Act that makes it harder for states to pass laws that would suppress the vote. So in Shelby County versus Holder in 2013, the court basically dismantled the pre-clearance process that required states who had a history of voter suppression to go to the Department of Justice and get clearance for any changes to their electoral policies. Now states can pass laws that move precincts, that change the way you vote, make it harder to stand in line, make it against the law to give water to people who are standing in line. All of these things that really have a suppressive effect on the vote, and particularly on the exercise of the vote by minority voters. The court has also essentially absented the federal courts from dealing with the question of partisan gerrymandering, like how we draw the districts for state legislatures and for Congress. All of that makes it harder to register your preferences in the democratic process. So, the irony of this whole decision is that it insists on giving this back to the people, but it's actually made it very difficult for the people to make their preferences known.
Thank you. All right, let me turn it over to the student thing. I really appreciate that. Our first question comes from Tyler, who's an 11th grader from Maryland, and it deals with how state legislators are reacting to this Dobbs decision.
My name is Tyler Phillips. I'm a rising 11th grader from Prince George's County, Maryland. My question is, what laws are states passing now that Roe v. Wade has been overturned?
All right, PG County in the House. Thank you for that question, Kyler. I think there are a wide range of different laws. So immediately after the decision in Dobbs was announced, we saw what were known as trigger laws go into effect. So these were laws that many states had on the books for many years that essentially said the minute the Supreme Court took an effort to overrule Roe versus Wade, whether in whole or in part, the state would immediately bring into effect a law that made abortion illegal in the state, and in some cases even a crime. So a number of these trigger laws have gone into effect in a number of jurisdictions throughout the country. In addition to that immediate legislative response, we've seen a number of states move to limit the opportunity for their citizens to leave the state to seek abortion care in other places. So they're debating this at this moment. They haven't necessarily enacted this, but this is something that is a topic of hot debate. Some states have modeled the Texas SB 8 enforcement mechanism. This was talked about a lot at the beginning of the year. Texas essentially deputized private citizens to file lawsuits against other private citizens if those private citizens had provided help or had provided an abortion to someone in Texas. A number of states are using that enforcement mechanism now to essentially deputize their citizens to report on their neighbors who are seeking abortion care. We've also seen some blue states, though, take steps to codify reproductive rights protections in their own laws, and also to take measures to indemnify physicians or otherwise protect physicians who are performing abortions in their state, especially if they're trying to perform abortions on patients who are coming from other states that are less hospitable to abortion care. So a lot of legislative activity going on right now on both sides of this issue.
Next question comes from Alexandria, a graduate student at Montclair State University in New Jersey, and she wants to know about the Supreme Court reinstating Roe v. Wade.
Hi, I'm Alexandria, and I'm a graduate student from New Jersey. My question was, is there a way the Supreme Court's decision regarding Roe v. Wade can be changed? And if so, what would the process be like for the Roe v. Wade decision to be overturned? Thank you.
So can this decision be overturned or counteracted in some way? Yes, but I think this is a real long-term prospect. I think in the short term, there is a conservative 6-3 supermajority on the court. I don't think there is much of an aperture for overruling this or rolling back what the court has done in the near future. But that doesn't mean that there's no hope at all. This was a 40-year project to roll back Roe versus Wade. It wasn't something that happened overnight. This has been a concerted effort to limit reproductive rights over a long period of time. And I think if individuals are interested in rolling back this decision that has rolled back reproductive rights, you have to similarly play a long game. And that's going to mean organizing, being politically active, thinking about the courts as political actors. One of the things that's so interesting about how all of this has happened is that the Republican Party, famously did not have a national platform in 2016 when Donald Trump ran for president. They simply recycled a platform from an earlier presidential cycle. And Democrats had lots to say about that. What they missed in criticizing the Republicans about that is that the Republicans really didn't need a federal national platform because they had recognized that they could basically enact all of their domestic agenda through state legislatures and through federal courts. So for years, they have laid the groundwork to essentially capture state legislatures and get them into Republican control. And in blue states where they're not in Republican control, they use the federal courts, and that's how they advance their agenda. Democrats have never seen either the state level politics or the courts as essential to their domestic agenda. And I think one of the things that needs to happen if you are going to roll this back over the long term is that you have to think about all of the different facets and institutions that are actually in play here. Democrats and progressives have really focused on Congress and the presidency and the federal electoral process and have really been inattentive to state and local and the courts themselves. And it's really, now you see the result of all of that. Like, you can actually do a lot in those different areas and basically assert an agenda that is at odds with the majority of the country.
We hear a lot about the need to focus on the state legislature and how it's maybe the most under talked about mechanism that's affecting our lives across the country. Thanks for that. Taylor, a 10th grader from Maryland, has this question about how the court's decision relates to birth control access.
My name is Taylor Gaston Love. I'm a rising 10th grader. I'm from PG County, Maryland. And my question is, will women still have access to non-prescription birth control?
So it's a great question. Again, PG County is just bringing the fire this morning, so good for them. I think you're going to have a really sort of uneven landscape in terms of access to contraception. The Supreme Court in the Dobbs opinion says that it is not taking on the question of contraception, but as we know, Justice Thomas in his concurrence makes very clear that he's very open to the prospect of considering whether the Constitution contains a right to contraception. So there will be litigation and challenges to questions about contraception. You've asked about whether over-the-counter contraception or non-prescription contraception will be available. It is right now available, but here's the real question. Now that the court has declared abortion no longer a constitutional right, the real question going forward is what counts as an abortion. And the Plan B pill, for example, which is a major form of non-prescription contraception, has been characterized by many in the anti-choice movement as an abortifacient on the misguided science that somehow in doing what it does, it actually is essentially providing an abortion. There's lots of doctors who say that this is not the case, but this is really a question of language and branding. And the anti-choice movement has really been very clear that they're going to think about Plan B and other types of contraception like that as a form of abortion. And if that is the case, then I think it really does create questions about whether or not certain jurisdictions are going to allow for Plan B or allow Plan B to be imported into their boundaries because it is technically an abortion. So that's one thing I think we're going to see a lot of going forward. What counts as an abortion and what forms of contraception are going to be brought into the milieu of being abortifacients and therefore prohibited under the laws that are being passed in the wake of Dobbs.
Our next question comes from Raina in Kentucky, and she wants to know how the decision and new state laws affect medical decisions regarding pregnancy complications.
Hi, my name is Raina, and I'm a college freshman in Kentucky. My question is about all the talk going around about treatment for ectopic pregnancies and miscarriages. Will people still be able to receive treatment for these life-threatening conditions before they become critical? For example, can a woman receive the methotrexate drug, which is an abortion drug, to treat an ectopic pregnancy before it ruptures? Or can she only receive treatment after it ruptures and her life's in danger?
So again, this is the $1 million question. Everyone has focused on Dobbs and its implications for abortion rights, but it also has real implications for those who are pregnant and want to continue their pregnancy or face complications in their pregnancy that require emergency medical care. Many of the laws in the states that are inhospitable to abortion allow for an abortion if it is medically necessary to save the life of the mother or the pregnant person, or if there's some other health reason. The real question, though, is what counts as an emergency? What counts as an exigent health circumstance that would warrant an abortion? And, I think you're hearing right now from a lot of physicians who are worried in the case of those states that have those private enforcement mechanisms. Their next door neighbor thinks is incompatible with the law. Are they going to be in trouble? Are they going to have a problem? And that creates a landscape of confusion and chaos, not just for patients who don't really know the scope of their rights, but also for physicians who don't understand and don't really know with precision the extent of how they can exercise their medical judgment. And so in the face of that uncertainty, I think what we're going to see is a lot of doctors waiting, maybe waiting too long in some cases, or not performing abortions at all, or getting out of the business of performing abortions because the risks are too high, the professional consequences are too high. And so in a situation like that, that kind of chaos and confusion is not just bad for patients, it actually is functioning as a deterrent to abortion care and is as effective a deterrent as an outright ban. So not only is this endangering the lives of patients on the ground, but I think it is purposely intended to sow that confusion so that individuals don't pursue their rights because they're not sure of what their rights actually are.
You're seeing it now. I mean, there was a case this week of a woman in Texas who went septic and was on a ventilator because they waited until she went septic. So is there a place for doctors to go? I mean, I'm just curious myself, like where did doctors go or medical professionals to figure out the law so they can care for their patients and do their job without fearing that they could go to jail for saving a life.
That's my point. I think doctors want to exercise their medical judgment, and they're worried that their medical judgment may not necessarily jibe with what the legislative judgment of an emergency, what that actually is. And, it's worth noting that in the period before Roe versus Wade, the real effort to liberalize abortion laws in this country came from doctors who argued that they should be the ones making decisions about when abortion was necessary, not legislatures in various states who didn't have medical training and weren't obliged under their professional obligations to provide necessary care in exigent circumstances.
Well, several people from ASP had questions like the one we have from Caitlin from Kansas. Caitlin from Kansas. And she wants to know about state laws that affect travel to go out of state to get an abortion.
Hello, I'm Caitlin Fox. I'm a senior in college from Kansas. Can a state legally ban a woman from going to another state to get an abortion?
Right now, we are seeing a lot of legislative activity from states that are trying to limit the mobility of their citizens who want to leave the state to seek abortion care in more hospitable jurisdictions. And I think this is really going to be a question going forward. Is the right to travel a constitutional bar on states who try to do this, or are we going to allow states to do that? There are a number of cases on the books about the right to travel, but it's a pretty sort of thin jurisprudence at this point. And more importantly, most of the cases dealing with the right to travel have focused on individuals who have left one state and gone to another state and are trying to seek benefits that are available in the other state. They really don't contemplate the prospect of someone leaving a state, going to another state, getting what they need there, and then going back to their home state. And so that really is the question. Missouri can let you go to California to get an abortion, but the real question is, can then Missouri punish you when you come back after having that abortion? And that's, I think, uncharted waters for this jurisprudence. It's also worth noting, just as a little bit of trivia here, in 1967, when the Supreme Court decided Loving versus Virginia, which allowed for interracial marriage, it invalidated a series of Virginia laws, including a law that made interracial marriages a crime in Virginia. But one of the other laws that the Loving family was prosecuted under was a law that made it a crime to leave the state of Virginia to go to a jurisdiction where interracial marriage was prohibited. And in fact, the Lovings had left Virginia, gone to DC, gotten married, and then came back. So we actually do have a history of this in this country of limiting how individuals travel for the pursuit of constitutional rights.
The final audience question is from Kai in New Jersey. Kai wants to know about the criminalization of abortion and the possibility of losing your right to vote as a consequence.
Hi, I'm Kai, and I am a freshman in university. I reside in New Jersey. And my question is, since only people with uteruses can receive an abortion, and in some states abortion is now a felony, and felons cannot vote, does the felony classification of abortion violate the 19th Amendment?
I'm not sure that there is a hook there for invalidating the felony characterization of abortion through the 19th Amendment. The 15th Amendment, which gave the vote to formerly enslaved men in the 1870s, also permits the limitation on the right to vote if someone has been denominated a felon. And so this simply tracks that same thing. I think the real question is how many states are actually going to prosecute the woman seeking an abortion as a felon. Most of the laws that are now in circulation really prosecute those who have helped the person to seek an abortion and those who have provided the abortion. So the physicians, most of them have exempted the woman from it, although that may be changing. And if it does change, then I think we will have a real question about whether or not women who have had abortions, if they are then criminally prosecuted, if they'll be able to vote, which again is another irony to this entire landscape. Justice Alito, in the majority opinion, notes that in dismissing the equal protection concerns around the right to an abortion, he notes that women enjoy the right to vote, and if they object to the withdrawal of this right, they can register their disapproval at the ballot box, but perhaps not.
Well, just to finish up, we had a lot of questions around ramifications of the Dobbs decision that didn't have to do with abortion law. And you spoke to this a little bit earlier in Justice Thomas's opinion. he left the door open for dealing with contraception and getting rid of same-sex marriages, or at least examining, I should say, contraception and same-sex relationships. Do you think this is a possibility? Is it likely?
I would say that Justice Thomas didn't open the door. He literally blew open a window, stuck his head out, invited people to bring challenges to these other rights. So the right to contraception, which is secured by Griswold versus Connecticut, a 1965 case. The right to same-sex marriage, which is secured by Obergefell versus Hodges in 2015. Even the right to same-sex sexual intimacy, which was secured by a decision called Lawrence versus Texas in 2003. He essentially says in that concurring opinion, all of these cases proceed from this line of substantive due process cases. And substantive due process is this idea that the 14th Amendment's grant of a right to life, liberty, and property subject to due process of law provides a substantive right to individual right, is a substantive font of individual rights for all kinds of things. The right to raise your family, the right to live among your family, the right to marriage. Justice Thomas says that can't be the case, that a due process right is purely procedural. There's no substantive content to it. And because there's no substantive content to it, there can be no substantive rights that flow from it. So just as the liberty clause of the 14th Amendment gave rise to this right to an abortion in Roe versus Wade in 1973, it also ceded these other rights, the right to same-sex marriage, the right to sexual intimacy, the right to contraception. And Justice Thomas is telling us that all of these proceed under an account of substantive due process that is constitutionally invalid and infirm and should be reconsidered. And he's very clear. There may be other constitutional provisions that permit these particular rights, but it can't be under the Liberty Clause of the 14th Amendment. And so what he's doing right now is essentially inviting litigants to challenge these laws. And so I think we need to brace for impact. We are going to see challenges to contraception. We are going to see challenges to the right to same-sex marriage. We're going to see challenges to the right to sexual intimacy outside of marriage, because all of those things are secured by those decisions that he has called into question.
Professor Murray, thank you so much for doing this today. You know, this was tricky for us. We try to think a lot about the best way that we can be of service to the community that has been nice enough to gather here and get them the best direct information without having to feel like it's biased, but yet can give them the opportunity to act in whatever way they see fit, and really getting you to define these laws and talk about where we can affect them in whichever way you so choose has been immensely illuminating for me, and I know for our audience.
Thank you so much for having me. This is a great project, and it was great to talk to these young people and hear their voices this morning. Thank you.
Thank you. It was so informative. We're very lucky to have you. Thank you.
Have a great day.
You
Bye-bye.
too.